Hi friends, I'm your friend Advocate Namish Nigotia and you are watching my YouTube channel Legal Advice for Everyone. Friends, many litigants ask me generally that sir, whether we can appear in person without lawyer, can we argue personally without the help of the advocate in the court of law? Can we file application personally without the advocate, or can we contest the entire case, civil, criminal, revenue, without help or assistance by an advocate? So answer is in positive. Yes, you can appear, you can contest, you can file the documents. What is the law with this aspect? How you appoint the advocate? We would like to discuss in this video. Before I proceed further with the video, I would like to request that if you have not subscribed my channel yet, kindly subscribe my channel, and if you like my videos, please like and share my videos so that it will give me a great motivation. Friends, Order 3 Rule 1 of the Code of Civil Procedure says appearance etc. may be in person by recognized agent or by pleader. I would like to read. Any appearance, application or act or to any court required or authorized by law to be made or done by a party in such court may, except where otherwise expressly provided by law for the time being in force, be made or done by the party in person or his recognized agent or by a pleader, provided that any such appearance shall, if the court so direct, be made by the party in person. What does it mean? It says, my lord, it says, sir, that any court, the party in person can appear in his personal case, he can file application, he can do all the acts required by the court, and this act can be done by the party in person, number one, then his recognized agent, power of attorney holder, or his pleader. Pleader means advocate. So the party in person, yes, of course, appear in the court. He can file the application, he can contest the case, he can file the documents, and he can submit the arguments. Now the question arises, what is section 32 of the Advocates Act says? It says, notwithstanding anything contained in this chapter, any court, authority or person may permit any person not enrolled as an advocate under this act to appear before it or him in any particular case. This is the discretion of the court. Even if a person is not enrolled as an advocate, any court or tribunal in its discretion may allow the person to submit the documents to argue the matter. Now, one interesting judgment by the Honorable Supreme Court. The title is Goa Antibodies versus R.K. Chawla. It has been reported in Supreme Court Cases 2011, Volume 15, page number 449. What it says, what happened in this case, friends? It's a matter of a company, and one manager of the company wanted to argue the case before the honorable court. So the court says no. Either if it's a personal case, certainly a person can appear and can argue the case. But if it is a matter of a corporate, then only recognized pleader can appear. What verbatim has said by the Supreme Court is, discretion of court to allow non-advocates to argue in person held. Natural person can be permitted to argue their own case even if he is not an advocate. But non-advocates cannot be allowed to represent an artificial person like company or corporative society or trust as in present case. So it says by the Honorable Court that you cannot represent in person to a company or society. On the contrary, you can of course represent your personal case in person. Now the next point is, which are the courts which is very easy to appear and to argue the cases? So there are many forums where there is no strict procedural law, where process is very easy, and judges and honorable presiding officers are generally very cordial and friendly. These are consumer courts like district commission, like state commission, like national commission. In this case, in these forums, a party in person can file a consumer complaint, can contest the case because there is no strict law, strict procedure is not there. And the family court, where matrimonial disputes are being adjudicated by the court. So generally family courts are friendly, they permit the litigants to appear, and generally they do not want advocates to appear and contest the court, and advocates are prohibited unless it is permitted by the family court to appear. Now, the other courts may be Permanent Lok Adalat, Labor Courts, Workmen Compensation Court, Human Rights Commission Forum, Banking Lokpal, Mahila Ayog, like that. These are the forums which are very cordial to the litigants, and there is no strict procedural law, so they can, party can appear in person and submit their dispute. Now the question arises, what happens in civil courts and criminal courts, in civil cases and criminal cases? So of course a party can appear in person even in civil cases, even in criminal cases, but they have to know the procedural law. And what difficulties arises because they do not know the procedural law. So if party is well acquainted with the procedural law, the stages of the case, the rules of drafting, how to submit the documents, how to make submission in the court, law points, what are the stages of the cases, how to controvert the arguments of the opposite party, and what are the citations of the Supreme Courts and Honorable Courts, and what is the law, what is the procedural law, so they can contest their own case in civil as well as criminal. But they must know the code of civil procedure, civil general rules if they want to contest the civil case. They must know the code of criminal procedure, criminal general rules if they want to contest the criminal case in person without the assistance of the advocate. Now, a crucial question arises that can you remove a lawyer in a running case? Many times what happens that sometimes litigants does not pay the entire fees, so advocates in a running case refuse to accept and they used to send their associates. Sometimes because of their busy schedule they are not attending the courts, and sometimes some disputes happens between the litigants and the advocates, and it annoyed the advocate and he is not appear generally in his hearing. So a crucial question arises, how to obtain the NOC from the advocate. So you have to go to the chamber of the advocate. If you have annoyed the advocate, you have to feel sorry, of course. Then you have to pay the entire fees whatever has been decided between you and honorable respected advocate, and then you can seek no objection certificate. You can respectfully say, sir, kindly provide us no objection certificate. We will either engage our other advocate or we will contest in person before the court. So after seeking no objection certificate, you can submit the no objection certificate before the court and seek the permission to contest the case in person, and court generally permits the litigant to contest in person. But litigant must be very careful while contesting the cases, because litigants does not having experience. In civil cases they can make some admission, and admission is certainly can damage your entire case. So experience is required. Either you should be well versed in civil proceedings, otherwise you should not do experiment in your own cases. This is my personal advice. So this video I would like to conclude, and yes, of course the party can appear in person, but some general rules which has been discussed in this video has to be followed by the party. Thank you friends, thank you very much.